The fourth panel of the day is Delegation to Private Actors, and the discussion will be moderated by Joanne Koob. Professor Koob is an assistant professor of law at the Scalia Law School. Her research and writing focuses on free speech, freedom of the press, and nonprofit law. She also directs the school's Liberty and Law Center, which works on issues pertaining to individual rights, the rule of law, and freedom of speech. In addition to offering public interest litigation training, a free speech legal clinic, and other programs, the Liberty and Law Center just launched a new program called Discussion Over Division, which seeks to address partisan divisiveness by fostering meaningful conversations between students of different political ideologies. At the Gray Center, we're very, very proud to work alongside the Liberty and Law Center, and so we're glad that Professor Koob can join us today. With that, I'll turn the discussion over to her.
Thank you, Adam. Well, I'm excited to be here with two experts in the area of private delegation. And so today we've heard mostly about when one government body delegates to another government body, and this panel is going to take us in a slightly different direction when a government body delegates to a private actor. And I have with me today Kimberly Whaley. Kim is professor of law at the University of Baltimore School of Law, whose scholarship focuses on the separation of powers in privatized government. Her articles have appeared in the Notre Dame Law Review, the Indiana Law Journal, and the North Carolina Law Review, among others. And her work is cited in leading federal courts casebook. In addition, Professor Whaley is an author, lawyer, legal analyst, and commentator on CBS, MSNBC, CNN, BBC, NPR, and PBS. She's a regular columnist for The Hill and The Bulwark, and she's also written for the Baltimore Sun and LA Times, among other publications. She is a former assistant U.S. attorney, associate independent counsel in the Whitewater investigation, and the author of How to Read the Constitution and Why, to be published by HarperCollins in June. Also forthcoming is The Outsourced Constitution, How Public Power in Private Hands Erodes Democracy. To my immediate right is Paul Larkin, Jr. He is the John, Barbara, and Victoria Rumpel Senior Legal Research Fellow in the Meese Center for Legal and Judicial Studies at the Heritage Foundation. He handles criminal justice, drug, and regulatory policy. Before joining Heritage in September 2011, Paul held various positions with the federal government in Washington, D.C. For example, from 1984 to 93, Paul served as the assistant to the Solicitor General in the U.S. Department of Justice. Paul received his law degree from Stanford Law School, a Bachelor of Arts degree in philosophy from Washington and Lee, and a master's degree in public policy from the George Washington University. He's written several articles about regulatory policy, including The World After Seminole Rock and Hour, The Trump Administration in the Congressional Review, Reawakening the Congressional Review Act, Chevron and Federal Criminal Law, Public Choice Theory and Occupational Licensing, and Regrounding the Private Delegation Doctrine for this conference. So first, we're actually going to break the traditional format and start with Kim, who's going to give us a little bit of background about what this private delegation is, and then we'll transition over to Paul, who's written his paper with much deeper dive into the issue. Kim?
Thank you, Joanne, and I want to thank Adam for inviting me. It's a real pleasure to be here. And who knew that the structural constitution would become such a sexy topic in 2019? But it seems to be crossing all the airwaves these days. Today, as was mentioned, we're talking on this panel about privatized government. My particular angle is a little bit different than what most of the commentators today have been talking about, which is the outsourcing of legislative power to the executive branch. And I see in the audience we've got people with deep expertise as well as others who do not. So my role here is to give more of a bird's eye view, and then Paul will get a little more granular, and then we'll have a discussion. So privatization defined, it's the range of efforts by the federal government to move public functions into private hands, and the primary way, of course, is by contract. So what it's interested me for a while is this idea that the Supreme Court is, even though the intelligible principle doctrine is pretty weak as far as a meaningful limitation on the outsourcing of legislative power to federal agencies, when agencies do it by contract, there's virtually no constitutional scrutiny, and this happens widely throughout the government. So delegations occur through agency personnel, and as I mentioned, very rarely discussed and more constitutionally problematic. And are there constitutional limits? The answer is not really. Why does it matter? The federal government pays over $1 trillion per year to private contractors. We hear a lot about the need to deregulate, that the bloated government bureaucracy, and that discussion doesn't seem to encompass private contracting, which has expanded as the federal government has maintained a basic steady size over the past 30 years or so. So when we're talking about routine contracting, the use of procurement contracts for supplies, maintenance of government buildings, that's not so much a problem. More controversial are when contracts outsource things that we think are inherently governmental, and there's really no legal mechanism. There's a circular, a guidance issued by OMB years ago, but that's not enforceable. There's all kinds of things private contractors do. A colleague of mine at Baltimore's written on, they run welfare offices. This, of course, has immense due process implications. So they make determinations of eligibility for benefits and sanction people for noncompliance. So it's something that government would do otherwise. And in the national security field, they perform law enforcement, national security functions, interrogate detainees, control borders, provide security for diplomats overseas, manage nuclear weapons sites, engage in battlefield operations, all things that have potentially constitutional components for individual rights, people that are come in contact with private contractors. So the animating principle of the Constitution, this isn't in there, but this is sort of what I've written about, is this idea of government accountability, that we want an accountable government so that there isn't arbitrary action against individuals. And of course, there are three primary means of fostering that, none of which necessarily applies to private contractors. So the structural checks and balances, they're outside the scope of all three branches. Electoral political checks on the legislative and executive branches, they're not, of course, elected private contractors. And then the individual rights provisions, three that I just pulled out, Fourth Amendment, prohibition on unreasonable searches and seizures, due process, First Amendment rights. None of these rights are going to adhere to private contractors under most circumstances, as they're not bound by these provisions. So why doesn't the Constitution provide a check? Of course, the Constitution confines government power, with maybe the exception of the 13th Amendment's ban on slavery. Doesn't apply to private parties, except under what I'll mention in a few minutes, the State Action Doctrine, in which the Supreme Court, as a practical matter, is engaged in a fiction that there's a clear dividing line between the public and the private sector. I mean, it's probably practically important, but at the end of the day, it's difficult to really meaningfully understand and justify. And the type of power outsourced, that is, if we are outsourcing core governmental functions, that's not the test for the State Action Doctrine to determine whether the private party would be treated as a constitutional actor for purposes of money damages or injunction by an individual. So the result, private parties operate on the government's behalf, largely with constitutional impunity. The typical example that I use in talking this over with regular folks is the TSA. Some airports, the TSA is outsourced. Others, they're they're government workers. So consider a video released in September 2015. A pair of TSA screeners at Denver International Airport manipulated scanning machines to trigger pat-downs on attractive females. Now, if that were a government actor, then there would be potentially constitutional rights against that person. If it's a private actor, and I think Paul will talk about this, you would be limited to tort remedies. And so one question is, does that matter? And I would suggest it does. It's not exactly clear why it matters, but it seems that we have constitutional limitations for reasons. So, and then the outsourcing extraordinary exception or example that I've talked about before is this notion of outsourcing law enforcement, outsourcing the Department of Justice. Of course, with the current administration and the various connections to the private sector, these kinds of scenarios aren't totally beyond the pale anymore, where they might have been 10 years ago. There's nothing prohibiting the creation of a privatized Justice Department, for example, at least constitutionally. So is it irrelevant as privatization increases? I think there's an argument the Constitution becomes less relevant. So here are some theories, as I mentioned. One is the state action doctrine. So this is a theory by which courts can determine whether private parties should be treated as government actors susceptible for violations of constitutional rights, but it doesn't look at the nature of the power in the first instance. So it doesn't prohibit the delegation. It only asks, well, now that there's delegated power, does the government retain so much control over the private actor that we're going to treat the private actor as if they were a government actor? And the irony there is the more authority that's outsourced, the less likely there'll be constitutional scrutiny. So it's a little odd. You would think that if the government retains the authority, then we're less concerned about constitutional viability or legitimacy with respect to actions by the private actor. The second is the private delegation doctrine, which I know Paul will talk about at some more length. This is a cousin of what we've been talking about all day, the non-delegation doctrine. In Carter Coal, the Supreme Court in 1936 struck down a statute authorizing local coal boards to determine coal prices and employee wages and hours. And since then, as with the regular non-delegation doctrine, the court really hasn't utilized it a whole lot, with the exception of maybe some discussion of it in a recent case called Association of American Railroads. The thing that's interesting here, among others, is that it doesn't apply at all to outsourcing through the executive branch. So if we talked a lot about Chevron, we talked a lot about agencies, the viability, legitimacy of agencies engaging in legislative rulemaking, but some of those functions are also outsourced to private entities around Washington, notice and comment review, for example. And the private delegation doctrine only looks to outsourcing by Congress, not by executive branch agents, and there's certainly a lot less constitutionally moored than Congress itself, and there's virtually no meaningful electoral accountability. The next one is the due process clause, again, a focus of Paul's paper. This idea being that if self-interested actors are given authority to regulate each other, that's really unfair. And the DC Circuit on remand, in the case I mentioned, held that economically self-interested private actors can't regulate competitors under the due process clause. I should mention, too, with the private delegation doctrine, the bottom line is that so long as the government has some kind of imprint of, we're okay with what the private actor does, the Supreme Court's been essentially sustained outsourcing delegations to the private sector. And then Fourth Amendment, this is something that I've thought about, this idea of big data and how it actually affects law enforcement. In the old days, government had more power to sort of do investigative and search type functions. Now with big data collection, the private sector actually sources that information, government can mine it, and this, of course, the collection by the private sector is extra constitutional. So it's sort of a wrinkle in privatization that is occasioned by technology, but it has huge, I think, Fourth Amendment implications that the Supreme Court is starting to grapple with. So what does this mean? Privatization and everything we're talking about as far as constitutional accountability is largely left to self-regulation, contract terms, which are generally only enforceable by the parties to the contract. So actual government contractors have a right of action against the government for violations of the contract, but the private citizens do not, to the extent to which private actors are not actually executing the terms of the contract pursuant to what's best for the public interest. And of course, the Freedom of Information Act and other statutes that exist to ensure transparency and governmental accountability at the agency level generally don't apply to private contractors. And contracts themselves are not even easily accessible to the public. I mean, they're not FOIable, but even getting your hands on them is kind of tricky business. So in terms of transparency, it's a different regime that we have with the administrative state. As I mentioned, novel concerns, I call this insourcing of private sector data, that a lot of, surveillance is now done by virtue of algorithms that create a new dossier that didn't exist before about individuals. We don't realize all our clicks and tweets and et cetera are actually creating a footprint that can be used to create new information. And then, of course, as I mentioned at the top of this talk, the structural constitution has now become super hot with the emoluments clause and other aspects of this particular president not divesting himself of his private interests. We're seeing privatized government in the White House in ways that we hadn't necessarily seen before. Last point, additional means of administrative legitimacy. Apolitical expertise of agency personnel. This is a big argument for why privatized government is a good thing, is that, we have market forces that ensure that they do a good job and that they're much more efficient. But of course, contractors are profit-seeking. One of the big questions here is, does it matter if someone takes an oath of office in executing their functions? Does it matter if your paycheck is set by the GSA level and that your function every day is to do what's best for the public interest? Or if it really, when you're deciding who gets welfare benefits, for example, does it matter how much your company is going to make off of that determination? As I mentioned, APA, other accountability statutes don't apply to private contractors, transparency, FOIA, and the press. This is kind of an issue that doesn't really make its way into the mainstream media. So in sum, distinction between public and private spheres, functionally meaningless. We have this state action doctrine that doesn't do a lot of work. Most cases, most courts actually reject state action challenges. The mission and purpose of the private sector uniquely includes accumulation and preservation of private wealth, which isn't traditionally associated with governmental functions. And so I'd make the argument that the Constitution is vital as a stabilizing force across the public-private spectrum to ensure foundational values such as fairness, equity, individual well-being. So the idea being, if due process, for example, is to prevent arbitrary government decision-making, how do we instill that in private contractors and ensure that those provisions are even in the terms of the engagement with the federal government?
Thank you, Kim.
Yep.
Paul, would you like to talk about your paper and perhaps comment on Kim's comments?
Absolutely. Thank you very much. Let me thank the center for inviting me to come and speak today and talk about the ideas I had in my paper. Let me thank all of you for taking some time out of your day. You have numerous demands on your time, and I appreciate greatly not only that you're here for my segment, but for any other segments of this event, this conference at which you're present. So thank you all very much. As my co-panelists said, most of the discussion today is in the form of, if you will, a vertical delegation. It is from Congress to an executive branch official, and then sometimes from an executive branch official to a private party. This is, if you will, if you want to look at it, maybe a horizontal or diagonal delegation. Because what oftentimes happens is you see the government deciding to return power to private parties in different ways. It can occur, for example, most commonly nowadays in the context of private prisons. You see that the argument is made that private prisons should be allowed to operate because they can provide the same services as the Bureau of Prisons in the federal case, and do it far more cheaply and efficiently. So you see this starting to happen. You also see that, and the additional argument is oftentimes made, that the reason the government should not have a monopoly on the variety of different types of programs and the like that it provides to the public is that the civil service system is unresponsive to the needs of a presidency whose views it disagrees with. So you see two very different arguments made in favor of privatization. One is that it's more efficient, and the other is that it avoids the battle between a new political administration and an entrenched bureaucracy. Now, the Supreme Court hasn't addressed this in constitutional terms very often, but it has in a few cases. The very first case came up a long time ago involving actually a state delegation called U-Bank. What happened in that case was the city of Richmond had delegated to private parties the authority to decide how a neighbor could use his property. He couldn't build, or she couldn't build past a certain line depending on how the neighbors looked at it. There were several other cases that followed, but U-Bank is significant because what it did was say this is a matter of due process. It said the government law that allows private parties to decide where a neighbor can build a property line allows the recipient of that authority to act in an arbitrary or self-interested manner. It treated this entirely as a matter of due process, which at the time probably seemed somewhat unextraordinary, because what you had was a circumstance where the government was potentially letting a private party act in a purely arbitrary manner in a way that the due process clause would prohibit the government from operating. Interestingly, however, since then, we now have taken all of the due process law and broken it down so that it fits into one of two categories. All of due process law is either procedural or substantive. Either the government has to follow a certain set of procedures before it can adversely affect your life, liberty, or property, or it can't do it at all. Yet, ironically, the problem that arose in the Eubank case was not one that the government couldn't do. In fact, the flaw that the Supreme Court found in what the government had done was that the government did not do precisely what it was allowing private parties to do. So the current due process doctrines don't really take into account this sort of structural, if you will, aspect of the due process clause. So what I think is important in this regard is to sort of step back and take a look and examine it from first principles. The delegations problems you see in Article 1 are problems that occur when the legislative branch decides for whatever reason to let somebody else make a law or do something along those lines. The delegation problems you see when the United States executive allows someone else to do it is a problem that arises under Article 2, because only officers of the United States can exercise government authority. So if the executive branch decides to outsource all of a certain function to people who are not officers of the United States, you have a problem there. And then you have delegation problems under Article 3, which deals with the judicial power, as panelists on the prior panel explained, the immediately preceding panel. We have had, over the course of the 20th century, a great increase in the number of issues that we will allow non-Article 3 judges to decide. And the question, therefore, is, have we exceeded the limitations imposed by Article 3 by allocating judicial power to people who are not judicial officers? The Due Process Clause, however, does come into play as well. And I think the reason it comes into play is in part because of the structural concerns the due process is designed to deal with, ensuring fairness in the procedure and prevention of arbitrary treatment. But also, ironically, because the history of the Due Process Clause, I think, addresses this sort of concern. Think back for a minute. From whence does the Due Process Clause come? It comes from Article 39 of Magna Carta, when it was written not as a matter of due process of law, but as a matter of the law of the land. Why was that clause put into Article 39? Well, think back to your English history. What happened previously was that the law of the land was essentially becoming the common law of England. It did not change when William I came over from France and became the new leader of England. He just accepted the customs and the mores and the like as the law of England and continued to apply them. He created a new judicial system, one that traced its authority to him, the crown, rather than to local villages, barons, and the like. But the customs and mores that were becoming the common law remained in place. The problem was that by the time you get around to King John, that he was violating the life, liberty, and property of people entirely at his whim. He was perhaps in some ways the archetypical example of an arbitrary ruler. The barons finally had enough of this and demanded, as an end to the Civil War, that he agree to Magna Carta. And as I mentioned earlier, Article 39, later renumbered 29, which is in many ways the most famous article of Magna Carta, prohibited the government from depriving somebody of life, liberty, or property, except pursuant to the judgment of his peers and the law of the land. Well, now take a look at what happens in a case like Eubank, where the city of Richmond decides it's going to allow private parties to make this decision. What has it essentially done? It has essentially said no longer will the law that governs how the government acts be allowed to intervene in this manner. We're just going to turn the decision over to private parties. In a way, ironically, therefore, it is somewhat the mirror image of what happened at common law when someone was declared an outlaw. What did that term originally mean? It meant that you were outside the protection of the law. All your property was cheated. You could not pass it down through intestacy. Anyone could seize you, arrest you, and take you immediately to the gallows. No law protected you. what essentially happened in the case like Eubank, and then again in later cases, Carter Cole, as the professor mentioned, is another one. What the government in essence did was say, we're taking away from all sorts of regulated parties, all sorts of affected and injured parties, whatever protection the law provides, and turning it over to an entirely different group of private people. In the case of Eubank, it occurred by turning the power over to the neighbors of the person whose property was affected. And in the case of Carter Cole, the federal government turned it over to a discrete group of people who were setting maximum minimum prices at which the entire community was to be governed. In essence, therefore, what you had in the Due Process Clause was an elimination of the law of the land that was supposed to be the principal governing factor preventing someone from being arbitrarily deprived of life, liberty, or property. It wasn't that a court was going to second-guess whatever procedures were involved. It wasn't that a court was going to say that whatever substantive decision the government was making was somehow unlawful and therefore could not be undertaken regardless of the procedures involved. It was a decision that in order for the government to do something adversely to you, they had to follow whatever the law of the land was. Now, you could say that the Due Process Clause continues that, and it does in essence. The last two words in this regard are equally important to the first two, due process. It's due process of law. What happens in private delegations is you are taking away all the law that normally would protect someone's rights, whether they are common law or statutory law or otherwise, and turning it back over to private parties. It becomes less a rule of law than a rule of the mob. What you have in those circumstances, therefore, is a true violation of what historically the Due Process Clause was designed to prevent. Now, granted, there are going to be problems. There are going to be problems in a variety of different contexts because you're trying to decide what, if any, supplementary forms of law are adequate in this regard. For example, if you take away all the federal statutes and regulations but leave in place state common law, it may well be that the state common law remedies that someone could obtain for whatever government action is now being authorized is more than adequate. Think back for a minute. Originally, the remedies that the colonists had and that the early members of the states had against unlawful actions by the federal government was not a statutory remedy. It was their common law remedies. And in fact, oftentimes the common law remedies were probably more valuable than the statutory remedies. Keep in mind, why was there so little enforcement of many of the different customs laws? Well, that was because anyone against whom the customs officials of the crown laid their hands could be sued for either a trespass or a tort and would be tried in a court that would be filled with people not appointed by the crown, but drawn from the community, and they would be the ones who would decide what's going on. So it may well be that state common law remedies are more than adequate in some instances to deal with this problem. Particularly difficult, however, are the problems when you're dealing with, for example, the use of different companies to serve in an overseas capacity. Why? Essentially, the United States doesn't have, if you will, the same rights that it would over in Iraq or Afghanistan that it does in the United States. Iraq or Afghanistan, at least at some point, were under the control of the United States and governed under the law of conquest, which Chief Justice Marshall described principally in connection with the authority the United States had over the Indian tribes early in the nation and throughout the later in the 19th century. But if you're talking about now a status of forces agreement between a foreign nation, which we have, for example, with the countries in Europe, and the authority the United States has, it becomes more difficult to figure out what authority the United States has that it can delegate and whether, in fact, the United States is delegating this question rather than a foreign nation delegating it to private parties. So it becomes a much trickier question in some contexts. But nonetheless, the important point to keep in mind, I think, is that there is, first, still room for the private delegation doctrine to operate. And secondly, if you look to the principle at which the doctrine should be designed to operate. It should be designed to prevent the government from shedding all of the requirements that otherwise would apply to actions by one private party against another, simply by denominating someone as now a government agent exercising government authority by delegating it back to the community or someone else. The government should not be able, in essence, to engage in a reverse outlawry by taking private parties, rendering them immune from any and all law, and allowing them thereby to injure other private parties without any remedy, judicial or otherwise. So, with that in mind, I want to thank you again for the opportunity to speak. The private delegation doctrine is a small one, but there are probably those that love it. And what we have is the ability today to find a use for this doctrine that actually is fully consistent, I think, with its historical origins. With that, let me thank you and turn it back to the moderator.
Thank you, Paul. Kim, I'd love to hear your response to what Paul just said.
Yeah, so I have a couple, or 3 or 4 points, and feel free to respond to any or none of them. The first is this idea of the law of the land, and my question is, what is the source of the law of the land? Is it natural law? Is it common law? And of course, if it's beyond common law, there's something called statutory law that creates new rights, creates the, Title VII banning discrimination on the basis of certain categories, for example, didn't exist in common law England. And so if that were the case, if Congress or state legislatures can create new statutory remedies, why couldn't that be then delegated? And then what would the law of the land be that would be an abdication of the government's authority in that instance? And I guess a related question is, so say in your point, when you use the Eubanks example, wouldn't common law principles still apply to how the private parties were exercising their power? So a tort remedy, for example, and then the delegation would be a defense, right? A defense to a tort. The idea being, listen, we were given this authority to establish these arbitrary regulations. Therefore, even though this is unfair to you and you might have some common law tort remedy, my defense is a statutory remedy, and wouldn't that address it? So that's the first point. The second kind of gets back to what I was saying, and I'm just curious where this idea of an imprimatur of government fits into your theory of non-delegation to private parties. That is, and this is something I just frankly really struggle with, the idea if a private party drafts a regulation soup to nuts, every detail of it, does all of the notice and comment process, construes the comments, decides whether it's consistent with the statute, and hands it to an agency, and the agency just rubber stamps it, like a magistrate judge's finding of facts and conclusions of law. Are we comfortable with that as a matter of the structural constitution and this concept of constitutional delegation? The third point has to do with the Appointments Clause. I know you mentioned in your piece that this was outside the scope, but of your article, but you also kind of made a broad point on how an exercise of government power by actors that were not appointed pursuant to the Appointments Clause would be unconstitutional. But of course, the Supreme Court has recognized other categories, including a federal government employee. And so would your position basically wipe out most of the administrative bureaucracy as well as federal contractors if only appointed officials could actually exercise that power? And then my last point had to do with the Due Process Clause and sort of the doctrinal implications of what you were saying. So the Due Process Clause, as you mentioned, there's procedural and there's substantive. And in your paper, you talk about how the objective of due process is to ensure that government adequately reduces the risk of a bad decision. And of course, it applies to life, liberty, or property, but that's been expanded well beyond, going to jail or taking away your house. It includes unfair denial of welfare benefits. So my question is, how does your conception of due process play out with, a private actor making a determination that, Mrs. G is not entitled to her welfare benefits, even though that would be traced back to a property right if it were a government actor, right? So a government actor would actually have to comply with the Due Process Clause. If Booz Allen is doing that determination, the Due Process Clause would not apply. So it's, the question is sort of how do you link up your theory of due process with the Matthews versus Eldridge balancing and the definition of liberty and property for purposes of the doctrine?
Sure. Let me try to take them in order. With respect to whether Congress can delegate matters that effectively render someone immune, say, for example, from Title VII, the answer is yes. Any statute that Congress creates, it can create an exception to. It already has exceptions to Title VII. I think they're for companies that are only 15 or fewer people. There was no Title VII until 1964, and as Professor Richard Epstein has argued, Congress could have gone the route to make sure that there were tort remedies instead available. So anytime you're talking about what Congress can or must do by statute, you have to take into account the fact that there's no requirement the statute exist in the first place. So if Congress decides it's better to not have a particular statutory regime in place, that's the decision for Congress to make. But also keep in mind, secondly, that Congress can't create state law. Congress can only create federal law. I mean, we recently had the case out of New Jersey where the question was whether the Congress had commandeered the New Jersey state legislature by telling New Jersey state legislature that whatever your law is dealing with gambling is frozen in place forever, and the Supreme Court went off on the commandeering doctrine. I think what happened was they essentially got kidnapped by a metaphor. What Congress was doing in that case was not commandeering anybody. What they were saying was you can't ever change state law. Well, Congress doesn't have the authority to create state law or to tell a state what the state law should be. So what you have is a circumstance, therefore, where if Congress takes away a federal regulatory regime, OSHA, for example, but leaves in place state law, the question then is, why is the state law inadequate in this regard to provide state remedies? The more difficult problem is, can Congress then, for whatever reason, preempt any state law and essentially take anyone out of any protection of the law whatsoever? That probably can't be done. Now, there may be circumstances where that can, generally speaking, and I think the problem you mentioned of people overseas is a particularly difficult one in this regard, because Congress only has whatever authority a foreign government gives it whenever it's trying to legislate for matters that occur overseas. But Congress can preempt state law, but I don't think they can eliminate state common law. Keep in mind that's somewhat along the lines of the distinction the Supreme Court has drawn in the Article III area. Remember the bankruptcy case and other cases that the Supreme Court has dealt with in trying to define the scope of what Congress can let bankruptcy judges decide and the like. Congress can't just turn all of state law over to bankruptcy judges, nor can it just say that there is no state law, I believe, that can be applied in any federal proceeding against someone like this. So I think you can say Congress may have limits on what it can do in this regard, but I think the principal limit is it can't take away state law remedies that a particular party might have and use those as the opportunity to get relief that you wouldn't get if there were a federal system. Like I said, it's difficult, and I'm not even sure what I think the right answer is with respect to trying to deal with this problem overseas because of the difficulty in figuring out what, if any, constitutional authority the United States has overseas in this regard. With respect to federal officers and state employees in Article 2, I didn't spend much time talking about federal officers and Article 2, but that doesn't mean that I don't think there is much of a limitation on what Congress can do. You take a look back at Eubank, Roberg, and Carter and look at when they were decided. They all predated the Supreme Court's decision in Buckley versus Vallejo, which was the first major Supreme Court decision giving any effect to the Article 2 officers of the United States responsibility. They said in Buckley, which was a 76 decision, that anyone who is exercising government power has to be an officer of the United States because only officers of the United States can have that responsibility. The result is if Congress delegates this sort of a power to private parties, what it is in the first instance going to be doing, I think, is raising an Article 2 issue rather than the Due Process Clause. I spent more time talking about the state issue and the like, because the due process clause applies to the states and the Article 2 does not. So whatever the answer might be in the Article 2 context, it's not going to govern what states can do in this regard. And it seemed to me the best way of trying to look at this was not limitations that the Constitution may impose on authority the states can give to private parties in light of whatever state civil service laws they have and the like. It's more appropriate to look at it in terms of whether they essentially can turn private parties into brigands by taking away any protection that a person has as a common law remedy. Finally, can Congress decide entirely, or the state decide entirely to privatize the due process clause? Once again, I think if a state said, we are not going to have a private system of welfare, there's nothing in the Constitution that requires a state to do so. There's nothing in the Constitution that requires anyone to have a particular amount of income, a particular home, particular medical care, and the like. So there's no substantive right there. A state may decide that what we will do is we will put X dollars into a system and we will allow people to go to physicians or go to private parties to decide what their needs are. And we will engage in oversight to make sure that we don't have the Acme company just handing out too much money to a private party. Because if there is no oversight whatsoever, then there's a tremendous risk of all sorts of essentially looting of the public treasury that can go on, because there's no limitation on private parties' ability to engage in these sort of activities. But a state, I don't think, could say, but we're taking away any state law remedies that someone may have for whatever conduct the person might find objectionable. It may be there's a tort remedy. It may be there's a quasi-contract remedy. It may be there's a fiduciary responsibility for someone administering a state program to act in a particular manner. Congress couldn't take away that state law set of remedies, and I don't think the state could either if what they did was essentially just deprive anyone of any sort of remedy they would have under any other federal laws or a state law.
So since about 1935, the courts have generally found that if a government agency or entity gives its stamp of approval on a privately made regulation, that is sufficient for constitutional purposes. It hasn't gone out and say that's an explicit requirement, but should that be constitutionally sufficient?
Anytime you're asked to decide whether X is sufficient, you have to ask yourself, what is it you're really being asked to do? You're being asked to draw an arbitrary line. That's what legislators are there for. They can decide the statute of limitations should be 1 year rather than 2 years. They should decide that the cutoff age for military service should be 38 rather than 42. Legislatures don't have to justify what they're doing because they have the authority to make laws simply by virtue of the fact that they were elected to those positions. And in the case of Congress, if they satisfy the bicameralism and presentment process, that's all the Constitution does. If, however, you're now going to say, well, we're not going to allow something to become a regulation because it can be written by private parties, you are essentially saying we're going to impose notions on the administrative process that are inapplicable to Congress. I mean, the idea that you would say a law is invalid if Congress didn't write the law itself, if it took the law as written by a private party or an organization or whatever, would be to entirely make up a theory of constitutionality that finds no source in the text whatsoever. I mean, there's no notion that a law has to be good to be passed. It just has to have a majority in each house. The same bill has to be presented to the president, and he has to sign it. That's it. So if Congress hasn't added to that for itself, and it hasn't, and it won't, for a court to say, well, we're going to superimpose that notion on agencies where there is nothing in the Constitution requiring it and no statute requiring that, seems to me to be just inviting courts to take whatever notion of the best political theory or the best workings of the government and enforce it against the executive branch without any grounding anywhere.
Well, I would say the grounding might be the non-delegation doctrine itself. The idea, I mean, comparing Congress taking lobbyists' input with an agency bureaucrat who's not even identifiable taking private contractor input are different because the bureaucrat is not democratically elected. And also this idea that we don't have sort of standards that apply that are different to agencies in Congress, it's not the case either, because of course we have the Chevron two-step and we also have the arbitrary and capricious doctrine. Those are statutorily grounded, but it would seem to me that if we're going to tinker with Chevron, it would make sense to take into account the extent to which under step 2 at a minimum, probably under step 1, the extent to which the agency itself did the drafting and did the actual analysis versus a private party that has other interests at stake, financial interests at stake, other than consistency with the public interest.
Keep in mind, I'm drawing a distinction between a circumstance where an agency relies on what a private party presents and one where you turn the whole matter over to a private party. Think what happens in litigation in federal district court. It is oftentimes the case that the district court judge asks private parties for findings of fact and conclusions of law. And sometimes they just take verbatim whatever they're given by the winning party. Well, that is subject to review on appeal. The losing party can challenge this on the ground that the district court didn't adequately consider the facts and the arguments and the law, because all it did was just sort of rubber stamp what the winning party submitted. And appellate courts will look at the argument of the losing party when it's made on appeal like that, and sometimes take those very seriously, and the losing party will win. You have the same situation if it's an agency that is signed onto it. You have a remedy at that point. The remedy is whether the agency has acted in an arbitrary and capricious manner under the APA. And if you think the agency was just simply sleepwalking and just signed whatever it was giving them, then you can say that's an arbitrary and capricious decision. But I don't think what you can do is try to say how much reliance on a private party renders something arbitrary and capricious, because now you're asking courts to engage in an undirected line drawing exercise. If you turn the whole matter over to private parties, by contrast, and there is no judicial review whatsoever, that's where the private delegation doctrine comes into play. But as long as an agency has to sign off on something, you have something that you can challenge regardless of how much the agency relied on a private party, because it's the agency that then issued the order that is enforced by law.
Along the same lines, how would you view when sometimes you have a government body that has a private party or person as a member of the governing body, as an ex officio member, for instance, and that governing body does engage in rulemaking?
Well, the presence of ex officio members, as long as they truly are just acting in a particular type of government capacity, doesn't, it seem to me, infect the decision-making capacity of a collegial body in the same way it would if you had a financially interested party. I mean, for example, if you have a three-person decision-making body and one of them is financially interested in the outcome, it's difficult, even if the decision is 3-0, to say that somehow the financial interest of that one person who should not have been there might not have affected the outcome in that particular case. But there are circumstances where we're willing to engage, and I think reasonably so, in the presumption that parties who are representing a particular interest can provide some value in participating, even if they can't be decision-making. Somewhat, but not exactly identical case happens, for example, in the case of the U.S. Sentencing Commission. The Justice Department is an ex officio member of the Sentencing Commission. It doesn't get to vote, but it does allow the Justice Department to bring its views to the attention of the other members of the Sentencing Commission in proceedings where they're all there together. And that there is value in that, because it's at least at those circumstances, if nothing else, where the government can make its position held, just like at oral argument in a case. It is the one time where you have all the members of a court together listening to the party. It may be that the decision was made when the court read the briefs because it was required by precedent or whatever, but the opportunity to have a person make that case there is still valuable. There's value in having someone perhaps as an ex officio member in those circumstances. It's more difficult to justify if the person is not truly an ex officio member but is a privately interested party. But that's less a delegation problem than it is a problem of biased decision-making.
Well, of course, we also have the Negotiated Rulemaking Act, which allows agencies to basically identify parties from various constituencies to do the drafting of the initial regulation, that the decision as to who sits around the table is not subject to judicial review. But I would argue the fact that that procedure is in place undermines the notion that having some private entity do it with a private party's own financial interest at stake when they're doing the drafting, and there's no discovery under APA cases, and agencies get to determine, unless it's different in the Enabling Act, what's actually in the record. So the fact of a private company drafting an initial regulation or even doing the notice and comment process isn't necessarily part of the record. And, we're lawyers in here. We know that, when you're in a negotiation, you want to be the one to put the first draft down as far as the settlement agreement. So the first draft does matter. I don't know what the answer is myself as far as how do you rein in outsourcing of government contractually when the only parties that can enforce that are the parties to the contract. And these decisions are being made by private parties that do affect regular people. And if those exact decisions are made by government actors, there are much more careful and rigorous provisions for ensuring accountability. And so it just makes me wonder, why have a constitution if it can all be just outsourced by a contract under the radar to people, entities that want to make a lot of money? I don't know the answer to that, because the state, it's kind of like standing doctrine that you mentioned under Article 3. There aren't really good, clear line drawing problems, and we can't have a situation where we constitutionalize everything a private actor does on behalf of the government. That doesn't work either, but it seems that we could shine a light on it a little more in the doctrine and not just focus on what Congress is doing, but also look at what the executive branch is doing.
So, and this will probably be the last question before we turn it over to the audience, but along that line, Kim, I'm curious, so given that that executing laws or agency delegations of execution of laws often does ultimately come down to policymaking when making incremental decisions. If we look at delegation to private actors or privatization as a constitutional problem, are we on a slippery slope? Is every privatization going to become a constitutional issue?
Sure, yeah, I mean, that's what I was referring to. And you also raise an interesting point in terms of the distinction between legislation and execution of legislation. In the Perez case, Justice Sotomayor thought about this and said, interpretation is something that agencies do and that executive branch does. They interpret something. If Congress does it, even if they're amending a statute, they're not interpreting the statute, they're actually creating law. And that, if you think about that distinction, it breaks down pretty quickly. And where's the line between interpretation? Where's the line between common law? Federal common law courts can create federal common law under certain circumstances, clear view trust. When is that infringing on the separation of powers and getting into the legislative branch's turf? And when is that actually just judges doing judging and resolving ambiguities in the law based on the facts before it? I think these are all really important separation of powers questions when it comes to the division of labor within actual government entities. When that gets into the private sector, it just seems like in my mind, it falls a little bit off the radar as far as these structural guarantees. If the framers of the Constitution prior to the Bill of Rights, their thought was the structure itself would ensure accountability. We don't need a Bill of Rights because the three-part structure, the checks and balances will make sure that arbitrary government decision doesn't happen, decision-making doesn't happen, but it's happening where the interests are not necessarily what's best for the public, it's what's best for the pocketbook. And I just think that's a big blind spot in this area.
Paul, do you have thoughts on that?
You asked about the execution of the law, and it reminded me of a great comment by John McKay when he was coaching the Tampa Bay Buccaneers years ago. After once again they lost one of their cases by a very large amount, one of the sports writers asked him, "What do you think of your team's execution?" And his response was, "Well, it's a little harsh, but maybe for a few players here and there." I think the problem that we have to focus on with respect to the constitutional aspect of this doctrine is whether what we're doing is trying to render people immune from any protection that the courts could provide. There are a lot of good policy arguments why we might not want private parties to engage in certain types of activities. For example, they may have too great a financial interest, generally speaking, in which case you would not want to put them in a decision-making position. But there are opportunities, if you will, to probably try to remedy some of these problems. I mean, for example, if someone delegated decision-making authority to private parties, but allowed for review under a state version of an Administrative Procedure Act, maybe that would be a sufficient remedy because you are not rendering someone immune to the law. You're just changing around the nature of the way the legal system is going to operate. You're using private parties in lieu of government officials. But states aren't obliged to use government officials for every state function. That's all a question of whatever the state wants to do in its own constitution. They're not required by the federal constitution to have an Article II officers of the United States requirement. But if they decided to have either a state remedy in the administrative process followed by a judicial process or just a straightforward tort remedy, maybe they have solved the problem because you're no longer essentially engaged in the mirror function of creating an outlaw.
Thank you. Does anyone in the audience have any questions they'd like to ask?
So this could be a topic for a whole day. I mean, there's touches on so many things,
I've got the day set aside.
including things like audited self-regulation and third-party certification and things like that, which is a big area of regulation, especially when foreign food is coming into the United States, and we can't put the FDA inspectors overseas, so we have to rely on third-party certifiers and that sort of thing. But it seems to me that you've drawn a couple of lines that I just want to explore briefly. One is with respect to the inherently governmental function line that you drew, and I think you accurately said that there's only a circular on that. But how strong is that line, and do you have any insight on how it's being drawn? I mean, if a government agency hires me to advise them on a rulemaking, of course they should have lawyers that do that, but they apparently don't, so they asked me to do it. I'm not going to say, well, that's inherently governmental, so don't hire me, but
Well, that's the point. I mean, if there's no speed camera on the street, you're going to speed. And so if the circular is not enforceable, right? There's no judicial review. So it's there in theory.
should there be a statute?
Well, Congress could do that. Congress could say that there's certain kinds of functions, and of course we get into line drawings on what is something that's inherently governmental. There's certain kinds of functions that have to stay within a federal paycheck, and that's, someone who actually has a federal paycheck. But there's not really an interest in doing that.
Federal employee unions are the ones that really want to enforce this, and so they bring cases sometimes. I remember when the air traffic controllers were being privatized, the unions didn't like that, so they went to court, and I think they lost. But so that's one line. And then the other line is what you mentioned, Joanne, about having to have some kind of governmental say in the final decision. So there are lots of things like, the HHS uses these intermediaries to decide Medicare A appeals, and the SEC uses the stock market and FINRA to really enforce against the brokers. They don't do it themselves, but they're there to review the rules of these organizations. And so the courts have said that kind of audited, or those intermediaries are okay. So that's another line that you seem to have identified that could be enforced maybe better. But those two lines seem to be the dividing lines that you've mentioned, so. I don't know if you
Well,
have
and
more
traditionally, I mean, from an original standpoint, of course, there was local sheriffs that were regular people and posses that would go actually enforce law. So there isn't anything, I think, that theoretically or historically bans it, but it does seem, we have so many conversations about the constitutionality of, say, designer agencies. You know, Congress gets really upset, the PCAOB, or I mean, the Supreme Court gets upset if Congress creates an agency in which the president doesn't have sufficient removal power, but if some RFP is issued in which there's quite a bit of outsourced power, and there's no necessarily removal authority that traces back to the president, there's no judicial review. So it just seems anomalous to me on that one end of the spectrum. If Congress is doing it, we're all over it from a constitutional standpoint. If someone who's not democratically elected and it's below the radar is doing it as a matter of an RFP and a contract, no one even looks at it.
Other questions? Well, in that case, one question here.
I'll pose it in a way that you could answer very briefly or not at all if you prefer. I love that you talked about negotiated rulemaking. I work for an agency and have seen a number of negotiated rulemakings, and we're in the middle of one right now. And it's interesting the way that you discuss conflict of interest, because the only people you recruit for your negotiated rulemakings are really the regulated community and the advocates who are in favor of more stringent regulation. They all have conflicts of interest, and if they did not, they would not be in the room. So it puts a really interesting twist on this to hear you talk about it this way. I'm so curious, is there any way to do negotiated rulemaking with some of these conflicts in mind, given that you're only in the room really because you are a stakeholder, and if you're a stakeholder, you do have a conflict of interest?
Well, the reason I raise that is because the fact of who's in the room is transparent. So if the idea is once that rule that's produced goes to notice and comment, and of course the agency can either approve it or they can amend it. Once it goes to notice and comment, then it goes out to final rulemaking, and then there's judicial review. That the fact you cannot challenge the makeup of the committee, but you could sort of get at maybe problems with the rationality of the rule in light of the conflicts that you identify. But
direct final rules.
yeah, we have those too. So these are our practical accommodations to reality, I suppose. And we also have non-legislative rules, right? So non-legislative rules where it's just not feasible to go through the entire notice and comment process. And so we have regulated community paying attention to things that are not necessarily, don't have the force of law, but they want to have answers. So there's a lot of pragmatic problems. But I'm actually glad to hear that negotiated rulemaking is alive and well, because I think I like the transparency aspect of it rather than having, a private party do it.
Well, thank you, everyone. Please join me in thanking our panelists.